Hello everyone, I'm Ben Holt. I'm a partner in VWV's commercial litigation team. I also head up our information law group, which is comprised of lawyers from across the departments in the firm. And collectively, we advise on things such as data protection, privacy, confidentiality, privilege, reputation and crisis management, contractual and regulatory obligations, information security, subject access requests, and freedom of information requests. We've got particular expertise within the healthcare sector and regularly assist healthcare clients with ensuring their information and data processes are fully compliant, as well as assisting with complex subject access requests and advising on and defending data breach claims and resolving disputes connected to these areas of law. The first part of the session is going to be held by Andrew. I'll be back later, so I'll at this point hand over to Andrew.
Thank you very much, Ben. So welcome to today's data protection update. I lead on the firm's data protection compliance work, and we've certainly been busy over the past year or so advising GP practices on a variety of data protection and information law issues. And so in terms of what we're going to cover today, I'm going to start off by looking at some of the key practical takeaways from the work we've been doing recently. I'm then going to give an update on the Data Protection and Digital Information Bill, which is set to reform data protection law once again. There's also some interesting new guidance from the ICO that I will cover off as well. And then Ben's going to cover some common features around data protection litigation and some key takeaways from recent court decisions and how they might affect yourselves as gatekeepers of sensitive health data. Next slide, please. So a lot of the work that we've been doing has revolved around advising GP practices and indeed other clients on subject access requests. So just by way of a brief reminder, anyone, whether that's a patient or a member of staff or anyone else, can make a request for a copy of the personal data that you hold about them. This is known as a subject access request. And these requests are very rarely made in isolation. So they're usually made in the context of a wider dispute or complaint, or even as a precursor or in relation to litigation. And so with that in mind, if you do receive an SAR, I would suggest the first thing you should be thinking about is just sort of your overall strategy. So before you sort of dive in and think about redactions and sort of collecting documents, what is the big picture? So sometimes, for example, it might be that the best approach is to apply the exemptions vigorously so as to withhold as much as possible. But equally, there may be times when you think you've got nothing to hide and you want to just be really open and transparent and sort of really try to give the requester as much information as you can, even if it be possible to withhold the information. Whenever we're asked to sort of look at a draft disclosure that someone's made, one of the things that sort of strikes me is quite often there's people include far more information than they need to, and that really stems from the definition of personal data. So personal data, your obligation is to disclose the requester's personal data subject to any exemptions, but personal data is not every single sort of document or scrap of information that might name someone. To be personal data, it's got to identify them either directly or indirectly and be about them. And so if we take a member of staff, for example, that means that the vast majority of the emails, documents that have your sort of that either been written by your staff or have their name on just won't be disclosable because it simply relates to them acting in the course of their duties. And in that sense, there isn't really any personal data in there other than perhaps their name and the fact that they work for you. So an email from a colleague, for example, updating the project, that wouldn't be disclosable because that's just not that person's personal data. It would only become disclosable if something else made it such. For example, if that email was used as part of a a capability or a disciplinary process, that might make it the individual's personal data. The other things to think about, I suppose, of this is first, you have a right to ask the requester for clarification if you process a lot of data about them. For example, if you've had someone who's worked for you for many, many years, and they've asked for everything, then you're entitled to ask them to be a bit more specific. For example, does it relate to a particular date range, a particular subject matter, and so on? Equally, I expect that you may have perhaps current or former employees who've also been patients. And so you could, for example, ask them to clarify whether their request relates to the data you hold about them as a member of staff or as a patient, or both. You have 1 calendar month to respond. However, you can extend the time frame by up to a further 2 months if the request is complex. And whether or not the request is complex really depends on the specific circumstances. For example, if you need to involve lawyers when you wouldn't ordinarily do so, that's a factor. That's just the request might be complex. Equally, if you're dealing with some complex issues around sharing information about the child with a parent, then again, that may point to the request being complex. You can also take account of your resources when deciding whether a request is complex. So if you're understaffed, if you're a smaller practice, then that's a factor that that you could use to argue that the request meets the complex threshold. We have been advising on these sorts of things really ever since the GDPR came in 5 years ago, and the ICO, the regulator, has never once challenged one of our clients where we've advised the client to go down the to extend the time frame under the complex criteria. So it seems like the ICO have a fairly low bar for accepting that a request is complex, and with SLs, it's really far more important to get them right rather than to rush them. So if you need more time and the request is complex, then that usually isn't a problem. Okay, next slide, please. So what about the exemptions? So as I mentioned, the requester is entitled to all of their personal data that falls within the scope of their request, unless an exemption applies. So I've set out on the slide here some of the more sort of common exemptions that we've used. So if information is both the requester's personal data and information about someone else, then it's classified as mixed personal data. And when you've got mixed personal data, you only have to disclose if either the other party has consented or it's reasonable to disclose in the absence of consent. So if, for example, you had a colleague who made quite a sort of a gossipy, unhelpful comment about another colleague, and that other colleague made a subject access request, then that email will be mixed data because it's both about the person who made the comment and the person whom the comment was about. And so you have to balance up their sort of rights in deciding whether or not you would disclose or share that. When it comes to patients, for example, so if a patient makes a subject access request, there are specific rules that mean that you generally can't withhold data to protect the rights of health professionals in the context of health information. So if a patient requests their records, then you can't sort of use mixed personal data exemption to sort of protect staff except in exceptional circumstances. So in that situation, the balance is very much in favour of sort of disclosure, of giving the patient their data. Equally, if a member of staff made a request, then you would sort of, you would be redacting and removing patient data. So it would obviously wouldn't be appropriate to share patient records with a member of staff in response to a subject access request. In terms of other exemptions, you've got the negotiations exemption. So this applies if disclosure would be likely to prejudice negotiations. So let's say, for example, that you were negotiating a settlement with a member of staff, and let's say there were some internal emails setting out what the partners might be prepared to offer the member of staff by way of settlement. So perhaps a best case, middle case, and worst case scenario. It would clearly be a nonsense if the member of staff could make a SAR to request a copy of those emails, because that would just completely destroy your negotiating position. And so those sorts of things are exempt. Equally, there is an exemption for management planning, and this applies to personal data generated in the context of certain management activities. So if there's going to be a restructure and there are sort of rumors, people are talking, if someone makes an SAR, you don't have to reveal information about where they are in the process unless and until the official announcement has been made. There's also an exemption for legal professional privilege. So in practice, that means most, but not all, communications with your legal advisors would be exempt from disclosure under a subject access request. What I would suggest is just be quite careful just in terms of applying the exemptions. So don't take a blanket approach. Think about each sort of piece of information you have and just make sure that you're sort of confident that you're applying the exemptions correctly. A question I'm sometimes asked is can a practice ever refuse to deal with an SAR in its entirety? And the answer is yes, if the request is manifestly unfounded or manifestly excessive. And so essentially what this means is that the request is so unreasonable that you don't have to sort of provide a response. So this may be the case, for example, if it's obvious that the requester has no real intention to make an SAR. So if they make an SAR, but then they offer to withdraw it in exchange for money, or even if you think that the request is just being made to harass and abuse your staff. In some circumstances, you can also refuse to deal with repeat requests. But it's pretty rare to sort of to be able to refuse to deal with a SAR in its entirety. The only sort of occasions where I've done this, where I've advised a client to do this over the past year or so, is first we had one where somebody was making highly defamatory and abusive comments about colleagues in social media. They made an SAR, and it seemed the purpose of the SAR was to sort of get extra material to make further comments and to post stuff online. And so in that situation, we advised the client to refuse the request. And happily, the ICO didn't. He went to the ICO, but the ICO didn't find against our client. So that was good. And then the other occasion was in relation to an ongoing dispute where, like clockwork, the complainant would make a new SAR on the first of every month. And it just seemed, it just seemed to be the case that he had no interest in his data. He was just doing it to sort of part of sort of the siege warfare that comes with sort of long-term and difficult complaints. And so we suggested to the client that request was excessive, and they didn't have to respond. Okay, so that was just some tips on dealing with subject access requests. I believe we now have a question. Could I have the next slide, please, Tamar? Okay, so I'll just give you a minute to have a quick read of this, and then perhaps have a think about what you think the answer might be. Oh, here we go. So the two partners, there's an exchange in a private email account. They've said, whatever we do, we need to make sure that Alan's gone before the end of year. He's rubbish. So do you think that's disclosable? I'll just give you another 30 seconds, then we will close the poll. Okay, so that's interesting. Quite a wide range here. So quite a split. So if we go to the next slide, please, Tamar. So this engages with an issue that crops up quite a lot, and it's to what extent are sort of private conversations caught by data protection law. And the position is if people sort of use private devices or private platforms for practice business, then yes, potentially what is shared there is potentially disclosable under subject access request and is potentially sort of caught by GDPR requirements. Now, just thinking about the case study we saw a moment ago, I think it probably is disclosable because it's clearly work related. It's an exchange between two partners, and the practice manager is kind of on notice that private platforms are used to deal with practice business. So sometimes these sorts of things do fall within the scope of an SAR. However, there is absolutely no obligation if you receive an SAR to sort of go around and ask people to sort of hand over their personal phones or to ask people to search personal devices. And you only need to be thinking about these sorts of things if you have a good reason to believe that they hold something disclosable. But what I suggest you do is just make sure that your policies and your training are very clear around sort of the parameters of using personal devices and personal platforms, in particular not sort of exchanging sort of confidential information on sort of private platforms unless you really want that sort of, to be the case. And if, for example, your policy says very clearly that staff can't use private devices or private channels for practice business, then that will help if sort of the requester sort of starts sort of suggesting to you that you should be asking people to search those devices. Okay, next slide, please. So another area that I've another sort of compliance issue I've seen in the sector recently is just around privacy notices. So I just thought I would cover this off as well. So under data protection law, as part of your transparency obligations, you have got to provide people with certain information about how you handle and use their data. And this applies to anyone you process personal data about, such as staff, patients, and others. And for example, you need to tell people about where you got their data, where you got it from, what you use it for, and also give people information about their rights. And whilst it seems that most practices have a patient privacy notice, I've seen a few cases recently where they don't have a staff notice. So just make sure that your privacy notices sort of cover everyone. So you've got a staff notice, a patient notice, and that they cover all the different ways in which you want to use somebody's their personal data. A compliant privacy notice is really, really helpful in relation to complaints. And that's because a complaint is often framed in terms of you had no right to share my data or you had no right to keep my data. If you can sort of point to where in your privacy notice you've covered this off, then that will sort of go a long way to dealing with the complaint. And if the person goes to the ICO and you can point to where it's covered in your privacy notice, it's much less likely that the ICO will look into it because they'll think that you've covered your because you've been transparent about your use of the data. Next slide, please. So another thing that crops up as this is when you sort of trust a third party to handle your patient or your staff data. So if you sort of use a supplier to handle data on your behalf, and just going back to basic principles for a moment, everyone under the data protection law is either a controller or a processor, and the controller gets to decide the purpose for which and the means for which personal data is handled. So they make the key decisions. A processor, on the other hand, can simply processes personal data on behalf of the instructions given by the controller. So a practice is clearly a controller for the data it holds about its staff and its patients. And indeed, if you share personal data with another healthcare professional or provider, then they will be a controller as well. However, if you sort of use a third-party hosted information management system to hold staff data, for example, then the provider of the information management system will most likely be a data processor. So whenever you share personal data, just be thinking about, are they a controller or a processor, and have we put in place what we need to do for data protection compliance? In particular, if you're sharing personal data with a processor, then you are required under data protection law, under the GDPR, to include certain clauses in your contract with them that cover things like information security, audit rights, and so on. And you're also required to carry out due diligence and checks on the supplier to make sure that they are handling your data safely in practice. Sorts of things you should be thinking about are they recognized? Are they certified to recognize the information security standard? Is the data encrypted in transit and at rest? Are their staff trained? Where is the data actually kept? So do they use sort of a recognized storage solution such as AWS or Azure? So these are things that you should be thinking about. And if the data processor mishandles the data, for example, if they suffer a data breach, you could potentially be liable for the processor's breach unless you've taken these steps. Sometimes it can get a bit tricky, for example, as to whether the provider is a controller or a processor. So imagine that you sort of outsourced your entire HR function. I think the provider would probably be a controller, because they've been making sort of important decisions, important HR decisions, which would require a sort of expertise and discretion that would sort of take them beyond simply being a mere processor. But equally, they could do some things that would sort of make them a processor. For example, if they did payroll, then they'd probably be a processor for the payroll element. Next slide, please. So that's just a summary of some of the more interesting stuff that we've been doing recently. I'm now just going to cover off some new ICO guidance and the latest on data protection reforms before handing over to Ben. So the ICO have been busy producing new guidance on a variety of topics. They're in the process of updating their employment practices guidance, which has kind of been around for sort of, I think, for forever, for over 10 years. And the ICO are producing the new guidance of chapter by chapter. So they've produced draft guidance on staff monitoring and processing staff data, and there'll be further guidance to follow during the course of the year. And in my view, they're taking quite a restrictive approach. I think that they're taking an approach that's quite favourable towards data subjects over organisations. For example, the ICO's monitoring guidance makes the point that even if you sort of don't allow staff to use work devices for personal use, staff should still have an expectation of privacy. And so you still need to be careful when sort of accessing staff emails or seeing what they've been up to when using their work devices. But clearly, you will handle extremely sensitive data about your patient. So I think that the ICO guidance just has to be sort of thought about in that context. And it's still appropriate to sort of monitor use of IT systems and so on. But just make sure that you are transparent with your staff. So make sure that your privacy notices make it very clear what sort of monitoring takes place. And I would also be carrying out a data protection impact assessment on any monitoring of your staff and your systems as well. The ICO has also produced new guidance on international data transfers. So if, for example, you use a supplier that transfers data to the USA, you'll probably need to do a transfer risk assessment just to sort of make sure that you're satisfied that the transfer doesn't sort of put people at risk and that it's lawful. So the ICO have produced a template transfer risk assessment. The ICO have also updated so one of the ways to make a international transfer lawful is to contract using standard contractual clauses. And the ICO have updated the old EU SCCs, the old EU standard clauses with new UK-specific ones, which now must be used for any new transfer. So again, if for example, you're using an online service that stores data in the USA, you need to make sure that the contract incorporates the new standard clauses, and you should also be carrying out a transfer risk assessment. Okay, next slide, please. So the final thing I want to cover then before I hand over to Ben is just around the data protection reforms. So last summer, the government introduced the Data Protection and Digital Information Bill. Now, this was set to reform all aspects of data protection law. So as things currently stand, data protection law is made up of three things. You've got the GDPR, which contains most of the rules. You've got Data Protection Act, which contains most of the exemptions. For example, the exemptions applicable to an SAR. And then you've got the privacy regulations as the third pillar, which cover things like cookies and electronic marketing. And the bill is set to reform all three. What's sort of underpinning all the change is the government wants a more sort of agile, light touch approach to data protection compliance. So it's really for the first time ever, they're kind of looking at rolling back the obligations slightly rather than sort of making them more onerous, or at least that's the theory. The bill's had quite a sort of difficult introduction. So it was scrapped by the Trust Administration as one of the first things they did in September. Apparently, they felt that it didn't go far enough, it wasn't radical enough, but it's since been brought back by the latest government, but it will probably reappear at some point shortly with further amendments. Next slide, please. So because it's all a bit up in the air, I won't sort of spend too long talking about what the changes might be. I just want to sort of cover off some key takeaways. The first of those is that, as it's currently drafted, the bill proposes to scrap the DPO role and replace it with a senior responsible individual for data protection compliance. Now, the SRI has got to be part of an organization's senior management, which is defined in the bill, which I'll just read out, means the individuals who play significant roles in the making of decisions about how the whole or a substantial part of its activities are to be managed or organized. So in some respects, it's almost the opposite of a DPO, because a DPO can't really be part of the senior management because there's a perception of conflict, whilst the SRI is kind of the opposite, because the SRI must be someone at senior management level. So the SRI could, for example, be a partner. It could potentially as well be a practice manager, assuming in practice they're involved in sort of key management decisions. Crucially, the legislation makes it very clear that the SRI can delegate responsibilities. So if, for example, you've got someone currently who's sort of looking after data protection, even if they wouldn't sort of be able to be the SRI, in practice, responsibility could be delegated to them as the sort of the day-to-day data protection lead. So I'm not sure what sort of if it'll make a big difference in practice, or indeed if this will appear, or indeed if the SRI will sort of find its way into the revised bill once it's published. There's also a more structured approach to dealing with complaints. So, for example, everyone will have to have a complaints policy, a data protection complaints policy. This is really about making it more difficult for people to make complaints to the ICO. So I think what's underpinning this is making the ICO's life a bit easier. There's also a more light touch approach to documentation. So, for example, the obligation to do a data protection impact assessment for high risk processing is going to be replaced by an obligation to do an assessment of high risk processing. But I'm not convinced it's going to be massively different. So the only change is that the new assessment, you only have to have a summary of what you're doing rather than sort of a lengthy description. So, you know, it's on the face of it, it looks sort of, you know, a bit more helpful, but I'm not sure what sort of difference it will make in practice. Perhaps more helpfully, the government are alive to sort of the nightmare of trying to deal with a difficult SAR and the fact that people will sometimes sort of make SARs tactically. So there's going to be a new exemption for vexatious SARs, and one of the criteria that points to a request being vexatious if it is an abusive process. So if, for example, you've got someone suing you and they make an SAR to try to sort of find out what information is held, arguably that would be an abusive process because there's a separate right under litigation disclosure rules. So it could make sort of dealing with SARs a bit easier, but the key will be how narrowly or widely the ICO interpret what vexatious and what abusive process means. Okay, next slide, please. So that was everything I wanted to cover. I'm now going to hand over to Ben, who's going to talk about some litigation updates.
Thank you, Andrew. Most of this is good news, actually, surprising for a litigator to be passing on. Healthcare providers obviously face data protection issues on a regular basis, including links to obligations on data processors, data breaches, complaints and claims. And as Andrew's explained, it's really important that healthcare organisations have adequate systems and processes in place to ensure that the data is protected and the risk of data breaches occurring is minimised. And that's particularly vital within the healthcare sector, where a significant amount of the personal data that you're going to be holding and processing is sensitive and special category. So to take an example, the sort of thing that we've seen on a few occasions, a receptionist who might speak to a mate about somebody who's been into the practice to have some sensitive healthcare discussion and has passed that on. The healthcare practice will generally have its proper systems in place. It will have given training. The access will only be available to those who need it, but it's basically down to a rogue employee. And over the past couple of years, the courts have confirmed the law here, which is now much more favourable to practices which are otherwise compliant. Although there are, of course, nuances and reputational considerations in addition to the strict legal position. And clearly the concept of confidentiality is particularly key within the healthcare sector to make sure that your patients still have trust and faith that their information is going to be kept confidential. I'm going to talk to you for about 20 minutes this morning on some of the prominent features of data protection litigation, some key decisions from recent years which have been positively received within the healthcare sector, and also the reduction of a surge of opportunistic claims, and also the change in data protection litigation landscape. And then I'll finish by summarising a few takeaway points. So can I have the next slide, please? Thank you. The introduction of the GDPR in 2018 obviously strengthened the rights of individuals to control their data and increased the obligations on data processors and controllers, and that led to an increase in data protection claims. Some of the common features of data protection litigation that we've seen are, and you may well have received these yourselves, sort of templated, very, very long, overly complicated letters quoting various causes of action, that setting out the law in great detail on the GDPR and the Data Protection Act, on breach of human rights, on breach of confidence, on misuse of private information. And that kitchen sink approach has been criticised by the courts for unnecessarily complicating matters. The inclusion of, for instance, breach of confidence and misuse of private information claims in addition to data breach is often tactical, and that's basically because they often, the claimants often buy after the event insurance premiums to cover the risk of having to pay out the defendant's costs, and that premium isn't recoverable in data protection but is in privacy proceedings. So there's a lot of tactical stuff going on there. And also the claimant law firms, you'll see them advertising their services on a no-win, no-fee basis in respect of data claims, which means that if the claimant loses the claim, the firm won't generally charge for its services. And that, combined with the ability to obtain insurance and potentially recover the premiums, it creates a market for claimant lawyers to promote the litigation on the basis of limited risk to the patient or the claimant. We often see those claimant lawyers seeking a very high level of costs, which often significantly often significantly exceeds the amount of the damages sought, and the level of insurance cover obtained is often nowhere near what's needed to cover your cost. But the cost that they've incurred in terms of trying to get the claim settled, the amounts can exceed the amount of the damages even at a very early stage, and it makes it very difficult to resolve the claims. The proceedings are often issued in the High Court, despite the low levels of damages. Claimant lawyers try and argue that they must be dealt with in the High Court, but that is simply wrong. And the court has confirmed that recently. The tactical aim of that is basically because you're more likely to get higher costs in the High Court than you are in the County Court. And particularly for a claim that is non-complex and worth less than 10 grand, it will generally be allocated to, you've probably heard of it, the Small Claims Court. And in that, the key factor for that is that you basically don't get any costs back. So that's very unattractive for the claimant lawyers to end up in there if they're in a no-win, no-fee scenario, because that means that they won't be able to recover the costs from you either. The courts are becoming more alert to that, and there's certainly been a clampdown on it. And claimant lawyers are also attempting to take advantage of the fact that legal costs associated with litigation in defending it means that from a pure balance sheet point of view, it's often more cost effective for the defendant to seek an earlier settlement than to actually fight the claims, even if you've got a strong position. And that's all led to a rather unsavoury claims market, driven largely by claimant lawyers sensing an opportunity to make easy money. And from my experience, when a serious breach has occurred, and for instance, a patient may have suffered as a result, healthcare practices are keen to sort it out in a fair way. But the majority of claims tend to be for very minor issues, such as, I don't know, a name and an address being accidentally shared and there being no consequence for it. Thankfully, the court's approach and attitude to these claims is hardening. Most of the cases that I'm going to talk to you about aren't specifically in the healthcare sector, but the principles and outcomes are still relevant. And there's a few interesting stories here for you. Next slide, please. So from 2021, the judiciary delivered several decisions, which I'll come on to in a moment, that changed the landscape in this area of litigation. And presumably as a consequence, in 2022, I personally saw the number of claims coming in from clients needing to defend them had really started to decline. And that general trend seems to be reflected in the court statistics. In the High Court in 2021, there were 293 data protection claims issued. But in the first 6 months of 2022, there was only 10, which would suggest a drop of tenfold. And the combined effect of these recent decisions is that the risks have become higher for the claimant lawyers in terms of not recovering their costs and for the insurers in having to pay out. And the High Court's started to take a more restrictive approach. It recognises, whilst it's important for people's data to be protected in modern day life, where storing and communicating data electronically is the norm, mistakes can and will happen. And when minor breaches with no real consequence occur, it should not be easy for opportunistic claimants and lawyers to exploit and profit from them. It's also important to note that what I'm talking about here are civil actions in the courts by those affected by the alleged breaches. Breaches can, of course, lead to sanctions by the ICO. That's not the focus of today's discussion. So let's just have a quick look at some key cases which demonstrate how the courts have approached litigation and how the tide has turned over recent years in that position. As I said, there's not many leading cases involving healthcare sector parties, but the law still applies. But coincidentally, the first one I want to talk about is, and that was from 2011, Grenier against Plymouth Hospital's NHS Trust. Mr. Grenier was had a paranoid personality disorder and was in a relationship with a nurse at the trust. The nurse had accessed his personal medical records over a 4.5-year period while she was working at the hospital, and he brought a claim against the trust for damages under the Data Protection Act for the effect on his mental health. And then the court held that the claimant was entitled to recover for personal injury, and that it was foreseeable given his pre-existing condition. But it did reduce the damages, given he was likely to struggle with his mental health conditions regardless of the incident. But he still got awarded £12,500. As we'll see later, I think if this case was in court again, I think the outcome would have been different. In 2015, the Court of Appeal decided in Vidal, Hall and Google, we don't need to go through the facts, but basically that said that you can recover damages for distress alone. So you don't have to show any specific financial loss. There's then the whole series of phone hacking cases. The most well-known one of that is Galati and MGM. Misuse of private information claim for the victims of the Mirror Group's phone hacking cases. And that included damages for their loss of control for the use of their private information. There's obviously been loads of settlements in the phone hacking cases since, and clearly the circumstances are exceptional with the invasions of privacy and breaches over many, many years. But the damages in that first decision range from £72,500 to £260,250. So we're talking significant amounts of money. And then in 2016, TLT against the Home Office. Damages were awarded to a group of asylum seekers for their mental distress as a result of the Home Office inadvertently publishing their personal data online. So, I mean, these individuals were asylum seekers. They were genuinely fearful for their lives as a result of this. A lot of them had assumed identities with secret addresses, with death threats hanging over them in other countries, and it was accessed overseas. So this must be worth a lot more than information about where someone from Coronation Street is going on holiday, yeah? Well, no, they got between £2,500 and £12,500. I think if that case was decided now, they'd probably get significantly more. But it demonstrates scenarios where claimants have been successful and damages were recovered and what sort of things can be recovered. But as I said, since 2021, we've seen a shift away in the way that the court deals with these types of cases. Next slide, please. The first one on this list, you may have seen in the press, it's Google and Lloyd. That was a really long-running and high-profile legal battle. Mr. Lloyd was pursuing a class action on behalf of millions of iPhone users in connection with an alleged breach regarding how some software installed by Google on some iPhones basically enabled cookies to track you. So that's lots of people who didn't even know a claim was being pursued on their behalf for a loss of control of their data, which they probably even weren't aware of or hadn't been affected by, at £750 a head, which would have resulted in a claim for about £3 billion against Google. And this went all the way to the Supreme Court, the House of Lords as was. And in a nutshell, the court decided that scenarios like this weren't suitable for class actions. Each claimant would have to demonstrate wrongful use of their personal data and material financial loss or distress resulting from it. So, I mean, in your circumstances, think if your entire patient database got accidentally put on the internet, something like that. And as with most large-scale data breaches, it's often the case that the people haven't actually been impacted and don't really care. Strictly, it's a decision under the old Data Protection Act, but it's probably likely to hold weight still. The next one is Warren against DSG Retail. That concerned a cyber attack. So again, something that you're all potentially prone to be victims of, against what was the Dixons and Carphone Warehouse Group system. And the hackers gained bank card information and other personal details about 14 million people. Mr. Warren, who was a customer, issued proceedings against DSG, and the High Court essentially held that Dixons were the victim of an attack here. For them to be liable to their customers, they'd had to have shown some sort of positive conduct on their part, which there wasn't. They were simply a victim. So Mr. Warren effectively lost. Slightly caveat that the only part of the claim that wasn't struck out was a challenge over whether DSG had their in place proper appropriate measures to secure personal data, which was still the subject of an ICO challenge. But the take-home message from that one is, if you do have appropriate systems in place, you're unlikely to be liable if you're the victim of a hack. The next case is one that's slightly closer to home, Rolf against Veal-Wasborough Wizards, which is us. And that was a case in the High Court that got reported. The Rolf family issued a claim against us, in which we secured the first, and I think so far only, reported decision basically confirming that where no credible harm can be shown, if you haven't passed a threshold for actual impact of it, you're going to lose. And the court had referred previously in the Lloyd and Google case to a minimum threshold being needed. So we were the first to push this forward, to actually take the case forward and succeed on it. And what happened? It was a single typographical error in an email address, which resulted in a letter relating to a debt claim being sent to the wrong recipient. The sort of thing that will happen to all of us at some point. The letter contained a nominal amount of personal information. It was simply to the other side. We were trying to collect some debt for a client, and one letter on an email address was wrong. And the person who received it got in touch, said, "I don't think this is for me." We said, "Thanks, yeah, that's correct." And they confirmed they deleted it, and all was in theory sorted. But no, the Rolfs then issued a claim against us, and we were successful in application to knock out the claim at an early stage. There's some quite fun quotes from Master McLeod here, who gave a very robust judgment, which has been well received, I think, generally by the community, and certainly I got a lot of positive LinkedIn comments when I was reporting on the outcome of this case that I was leading on. Master McLeod said, "In the modern world, it's not appropriate for a party to a claim, especially in the High Court, for breaches of this sort, which are frankly trivial." She criticised the claimants and called their claim plainly exaggerated, with a frankly inherently implausible suggestion that minimal breach caused significant distress and worry, or even made them feel ill. She said, I think this is my favourite bit, "In my judgment, no person of ordinary fortitude would reasonably suffer the distress claimed arising in these circumstances in the 21st century," which was stronger than she needed to be, but I think it was sending out a clear message that the court is fed up of people bringing these silly little claims which haven't really affected them. Johnson and Eastlight, another case that concerned a social housing customer who accidentally was accidentally sent rent statements for numerous other customers. And the claimant's approach to the litigation, they issued in the High Court, of course they did. It was heavily criticised, and the claim was transferred down to the County Court. And Master Thornett in that said, "No serious privately paying litigant would contemplate spending over £50,000 in costs, not all of which may prove recoverable, even in the event of success, and similarly expose themselves to the risk of significant adverse cost orders following a High Court litigation if unsuccessful, for damages of less than £3,000. The presentation and processing of this case today in this forum has, I'm satisfied, constitute a form of procedural abuse." Similarly, in Stadler and Curry's, oh, this is quite a fun one. The court again made it clear that the High Court isn't the appropriate venue for low value data protection claims. This one relates to a customer who basically got a smart TV, had put their Amazon Prime passwords in so they could access Amazon Prime, download the films, etc. TV broke, sends it into Curry's to get fixed. It doesn't, so he gets a new telly. It's then refurbished and is sold to another customer. That other customer, it isn't wiped before that happens. The other customer spots that there's an Amazon Prime account on there and buys a film for £3.49, which Curry's reimbursed. And they also give Mr. Sadler £200 gift voucher as a gesture of goodwill. But he still issued a claim in the High Court, which the High Court then transferred down to the County Court and said, no, this should be on the small claims track, so you shouldn't be able to get any of your costs back. So that, surprisingly enough, was broadly the end of that case. Again, in Ashley and Amplifon, this is an employer accidentally disclosing an employment contract to the wrong employee who had the same first name, just one of those things that happens. The High Court transferred it down to the County Court and again to the small claims track because of the low value. And just a last one on this page, just a good one for giving a recent steer on what these claims are worth. Driver and the Crown Prosecution Service, they sent an email to a member of the public which indicated that a decision was being made to charge a criminal suspect. And that indirectly allowed the suspect to be identified. And the High Court decided that, yeah, it was a breach, but it was at the lowest end of the spectrum. The distress would have been modest, particularly bearing in mind their identity had already been disclosed by the press. So it gave an award of £250. So in terms of how much is a low value claim worth, the court is saying that this is at the lowest end of the spectrum. 250 quid is probably your benchmark. Also helpfully, though, there's been some important cases about vicarious liability in this context, i.e. whether an employer can be liable for the actions of an employee in accessing certain data. And again, it's good news for organisations. I think we're on the next slide, please. Or maybe not. Oh, well, don't worry. Thanks. Oh no, it is still that slide, sorry. The first one of those in terms of is the employer liable for rogue employees, Ali and Luton Borough Council. This concerned a social worker employed by the council who accessed a social care database to obtain sensitive information about the claimant. So again, a situation that you can relate to in terms of one of your employees accessing sensitive information about a patient. She then disclosed this information to the claimant's estranged husband, with whom she was in a relationship. The High Court held that the council was not vicariously liable in those circumstances because accessing this information in question, the social worker had gone off on a frolic of her own. Despite having access to that data through her employment, the access of the records was not done for reasons connecting with her role, and she knew it was wrong to do it. Underwood and Bounty is in the healthcare environment. This contains patient notes at the end of patients' beds in hospitals. A mother and child brought claims against Bounty UK and Hampshire Hospitals NHS Foundation Trust. Bounty, you may be aware, they operated a data broking service and provided pregnancy and parenting support services. And Bounty had an arrangement in place with the trust, which permitted them to access new mothers and enable them to lawfully connect contact details for the purpose of distributing information relating to pregnancy and parenting. Mrs. Underwood alleged that when she gave birth to a child at hospital operated by the trust, a representative of Bounty, who she had signed up for services with earlier that year already, visited her in hospital and accessed the patient data sheets located at the end of her hospital bed. She claimed the Bounty representative had accessed the information of her and her newborn child without permission and had unlawfully processed the personal data. And she also alleged that the trust was also responsible for this by failing to take appropriate measures to prevent Bounty from accessing that data. The claim against the trust proceeded all the way to trial. The court held that the trust could not be found liable for breach of data protection purely because they made the documents relating to care and treatment of the claimants available for use by the trust staff. Obviously, the hassle of trying to find another system of keeping the key patient data other than at the end of the bed would be a hassle. It's not worth it on the balance of interests in terms of patient safety, all sorts of reasons. And it was necessary for practical for staff to be able to perform the duties. By leaving the notes at the end of the bed, they didn't make the data available to Bounty. Rather, it was Bounty representative who accessed them without consent, and therefore they weren't liable. The trust was not liable for the wrongdoing committed by Bounty, and the claim should never have been made against the trust. It's also interesting, the data in question, it was the name, the gender, and the date of birth. And the court also noted that wouldn't be sufficiently serious to engage a misuse of private information claim. In addition to those two cases, there's been a magistrates court recent decision where an individual was found guilty of unlawfully accessing records of patients without the knowledge of the trust he was working for, without business reason for doing so. And the court fined that individual a total of £3,000. So that acts as a reminder that individuals and your employees can be personally prosecuted for accessing data unlawfully and should only access the data where there's a legitimate and proper reason for doing so. We are on the next slide now, please. So just to round up, what's this recent data litigation taught us? Data breach claims in respect of minor incidents with minimal data involved have sadly become very commonplace. Until recently, there'd been little case law grasping the nettle in these actions. Due to the increased use of technology, it's inevitable that from time to time something will be disclosed in error to an incorrect recipient, and it's increasingly common for organisations to face claims against them, often with claimants seeing a one-off minor mistake as an opportunity for financial compensation in situations where they've suffered only minimal or even no loss or distress. And the decisions that I've talked about here will hopefully be causing claimant lawyers and insurers to take stock of their approach, and will also offer data controllers some comfort. I must say it's fairly rare for the individuals affected to be pursuing the claim without lawyers, now that the lawyers are getting less keen on it. That they seem to be dying out. Where claims are genuinely serious breaches, data protection rightly gives individuals the ability to seek redress, and most healthcare organisations will want to resolve the matter in a fair manner. But thankfully, the landscape seems to have shifted where that is simply not the case, where it's just opportunistic claims. I think the growing frustration with low-value data protection claims being issued in the High Court with little or no attempt to demonstrate financial loss or distress is now very apparent. While they're not all being struck out, there's a strong message that such claims should be issued in the small claims track of the county court, where, as I said, they won't be able to recover their costs. This doesn't mean that you won't face potential claims. Often these are, but it's worth noting that these are often covered by some form of legal expenses cover. You may have commercial insurance. Sometimes healthcare sector organisations will give you backing to defend these claims. So it's always worth checking the position in that regard if you do face any claims. So in conclusion, the tide does appear to have turned over the past couple of years of this sort of claims, and I anticipate that trend continuing. Minor data breach claims are looking less and less attractive to pursue, and we expect to see these number of claims continuing to decline. So hopefully this all provides your practices with some comfort and pause for thought if you are faced with a data breach claim. Obviously, the importance of protecting data, and particularly health data, which is of course especially sensitive, remains paramount, and all your practices need to make sure you have the correct systems and procedures in place, both in terms of minimising the risk of claims and indeed responding to ICO investigations, but also obviously from a reputational perspective. And that brings me to the end of my bit. Thank you.
So we've just got one question, which I'm happy to answer. So the question is, we're getting SARs sent through a solicitor or insurance company, seemingly to avoid paying for information. Is this allowed? We send the SAR info to the patient, but is this correct? So the position is different depending on whether the SARs come from a solicitor or from insurers. So with solicitors, they are entitled to make an SAR on behalf of their client, but you need to be absolutely clear that they have their client's authority to make the SAR, and it needs to be absolutely clear what that authority extends to. So what information is being requested, and so if they want the whole file, then the authority needs to say that. But assuming you've got authority, then yes, you can deal direct with the solicitor. Insurers are a bit different. The ICO gave a view a few years ago that insurers making SARs for information was an abusive process, and the concern was that it would end up insurers would end up getting all sorts of irrelevant information that they just didn't need, and which would put the practice in breach of its obligations by sharing that information with insurers. So you're absolutely right. If you get a request from an insurer, please do send the information to the patient. The BMA have produced a template letter that you can send to the patient that gives the patient the option of either receiving the response direct to the patient or asking the insurer to make a request under the Access to Medical Records Act, which is really what the insurer should be using to make the request, because that limits what you have to disclose to what's relevant for the insurer's purpose.